Hi everyone. Today we are going to discuss about some of the important topics under environmental law. So concept of environmental protection. Meaning, environmental protection refers to any measure that is taken to conserve, maintain or preserve the state of the environment. Protection of the environment can be done through reducing pollutants or anything that leads to its degradation. Conservation of the environment aims at keeping it safe and healthy. Preserving is also used hand in hand with the term of conserving. Now, protecting of the environment can also mean that the environmental practices that the human race indulge in are sustainable to help avoid avoid damaging or harming the ecosystem. Now, why should we protect the environment? The environment supports our life. The natural process that occur in the environment promote the existence of life. With the current scientific innovations, the environment is endangered. There is the discharge of many harmful greenhouse gases that disrupt the natural process of the environment. The increase in the number of yeah, cases being driven is hazard. That is, the pollutants being expelled to the environment is hazardous. The use of low graded plastic such as PVC is another added negative impact to the environment. With all these harmful things going on, the environment becomes our responsibility as we are part of it. Now, importance of environmental protection. The first one is to protect and save our lives. That is obvious. Now, the second one, the environment has suffered due to the scientific inventions. The third, the discharge of carbon gases. Fourth, uses of low grade plastics. Five, biodiversity is important. Now, six, it is our moral obligation. Seven, environmental hazards are dangerous. Now, eighth, to create awareness. Ninth, to have a sustainable development. 10. Plant trees along sea coastlines or sea or beach or the coastlines. So for all this, there is importance of environmental protection because that is the basic of our life, and the natural resources, it does not belong just to us but our future generations too. That is what we why we emphasize on sustainable development. Now, how to protect the environment? We can take the following steps to protect our environment. That is, some of the general measures are planting trees, use green technology, that is, wind and solar power, then use less chemicals, and the foremost is that we should create an awareness among everyone because environmental protection is not a one man army thing. It is something that is to be done in a mass scale and by everyone. Each and every person should be responsible to keep the environment safe and healthy. Thus, the concept of environmental protection arose, which necessitated the creation of a new branch of law known as environmental law. The Stockholm Conference on Human Environment in 1972 passed or paved a way for the international efforts for the protection and preservation of the global environment. It led to the recognition that all human beings are entitled to a healthy and protective life in harmony with nature. This recognition was responsible for the enactment of various environmental laws. The main objects of these laws are to preserve and protect environment and to prevent environmental pollution. Now, definition of environment. Section 2, Subclause A of the Environmental Protection Act 1986. Section 2, Subclause A of the Environmental Protection Act 1986 defines environment. Environment includes water, air, land, and the interrelationship which exists among between water, air, and land, human beings, other living creatures, plant, and property. So, with respect to environmental, protection, we can conclude that the environment is very important for the existence of life. It supports living things, and protecting it should be our first priority. Environment is our responsibility. Take care of it, and it will take care of us as well. It is a win-win situation. Scope of Article 232 and 226, or the judicial activism with respect to environmental pollution. This can also can be considered with respect to public interest litigation and environmental protection. So, uh, another way in which the question can come is discuss the remedy of the compensation developed by the judiciary through its writ jurisdiction. So, writ jurisdiction is Article 32 and Article 226. And how far locus standi have been relaxed in this respect, and that is with respect to the PIL. So, the writ jurisdiction or the relaxation of the locus standi with respect to environmental protection or such issues. Now, prior to 1980, only the aggrieved party could personally knock the doors of justice and seek remedy for his grievance, and any other person who was not personally affected could not do so as proxy for the victim or the aggrieved party. But around 1980, the Indian legal system, particularly the field of environmental law, underwent a change in the terms of discarding its earlier approach, and instead they charted new horizons of social justice. And this period was characterized by not only administrative and legislative activism but also judicial activism. In a modern welfare state, justice has to address social realities and meet the demands of time. Protection of the environment throws up a host of problems for a developing nation like ours. In determining the scope of the power and function of administrative agencies, and in striking a balance between the environment and development, the courts have a crucial role to play. And here comes in public interest litigation or the relaxation of locus standi. The acceptance of public interest litigation, that is social action legislation. So PIL is also known as SAL, that is social action litigation, as a legitimate method to enforce the fundamental right has practically made the conventional approach to locus standi irrelevant. PIL means a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or class of the community have have a persuasive interest or some interest by which their legal rights or liabilities are affected. Most of the cases are filed by lawyers and social workers of the enforcement for the enforcement of the fundamental rights. Now, at present, most environmental actions in India are brought under Article 32 and 226 of the Constitution. So this shows the how important role does the rich jurisdiction of the judiciary plays on environmental protection. The writ procedure is preferred over the convention at suit because it is speedy, relatively inexpensive, and offer direct access to the highest courts of the land. Environmental pollution being directly related to human health and well-being of the people, the Supreme Court and High Court respectively entertain writ for protection and improvement of environmental and issue directions or orders to undo the cause of pollution for the protection of environment from degradation. A person whose fundamental rights are violated can move either to the Supreme Court under Article 32 or to the High Court under Article 226, that is Article 226 of Indian Constitution, for enforcement of his fundamental rights. Now, some of the case laws where Article 32, Article 226 and PIL have been used. The first one, Ratan Municipal Council versus Vardi Chand, that is AIR 1980. Ratan Municipal Council versus Vardi Chand. In this case, the Supreme Court has given mandatory direction to the public bodies to implement specific plans to provide a proper drainage system to stop in affluents from the alcoholic plant flowing into the street and to provide sufficient numbers of latrines. Now, another one is State of Tamil Nadu versus Hindstone, that is AIR 1981. State of Tamil Nadu versus Hindstone. In this case, the Supreme Court has recognized the need to conserve and protect natural resources like rivers, forests, and minerals which constitute natural wealth. And the case law is Rural Litigation and Entitlement Kendra, that is RLEK versus State of UP. And this is one of the most important cases, and we come across this case law in different headings, that is RLEK versus State of UP, AIR 1988, Rural Litigation and Entitlement Kendra versus State of UP, AIR 1988. This is commonly known as the Dehradun Quarrying case. The court directed the central and state government to take steps to prevent illegal mining, which could result in ecological imbalance. So it also showed right to live in a healthy environment. That right was also brought by this case, that is RLEK versus State of UP, right to live in a healthy environment. Now, MC Mehta versus Union of India, AIR 1988. So most of the PILs, the landmark judgments with respect to PIL is from MC Mehta. And he has played a very crucial role with respect to welfare of the women and children as well as the environmental protection. So MC Mehta versus Union of India, AIR 1988. It is also called as Tanner's case. So here the canneries discharging the tanneries discharging effluent from their factories resulted in the pollution of water to holy river of Ganga. Or this is also known as the Ganga pollution case. That is MC Mehta versus Union of India 1988. The court held that such tanneries without treatment plan should stop its work. Now another important case again from MC Mehta, that is MC Mehta versus Sriram Food and Fertilizer 1987. MC Mehta versus Sriram Food and Fertilizer 1987, and it is commonly known as oleum gas leakage case. In this case, major leakage of oleum gas affected large number of persons. The Supreme Court applied strict and absolute liability to compensate victims of the gas leak. And in this case, right to live in a pollution-free environment was laid down. So right to live in a pollution-free environment was laid down by oleum gas leakage case, that is MC Mehta versus Sriram Food and Fertilizer 1987. And again we have a case from MC Mehta, that is MC Mehta versus Union of India 1992, and that is commonly known as Carbide case. MC Mehta versus Union of India 1992, which is Carbide case. Environmental pollution due to the stone crushing activities in and around Delhi was challenged, or that was the issue here. Supreme Court observed that every citizen has a right to fresh air to live in pollution-free environment. So that was held in Carbide case. And again we have a case from MC Mehta, that is MC Mehta versus Union of India 1997. So that is also known as the Taj Mahal case or Taj Trapezium case. The Supreme Court directed that the industries operating in Taj Trapezium zone using coal as industrial fuel must stop functioning and they should be shifted to the alternative site provided under the Agra Master Plan. So that is with Taj Trapezium case or Taj Mahal case, which is MC Mehta versus Union of India in 1997. Now, just to summarize the MC Mehta case, the first one we have is 1987 case, and that is oleum gas leak case, which came in 1987, where right to live in a pollution-free environment was laid down. Once again, these are MC Mehta cases. In 1987, it was oleum gas leakage case. In 1988, it was Ganga pollution case. Then in 1997, it was Taj trapezium case. And 1992, we have the carbide case. So once again, 1987, oleum gas leakage case. 1988, Ganga pollution case. Then 1997, that is Taj trapezium case, and 1992, that is carbide case. All these cases were by MC Mehta, were public interest litigation by MC Mehta. Now another case law, that is Murali S. Diora versus Union of India, that is in 2001. Murali S. Diora versus Union of India 2001. The Supreme Court held that public smoking results in air pollution and is violative of fundamental right under Article 21 of the Constitution. So, Murali S. Diora versus Union of India is regarding public smoking, and the Supreme Court held that it is violative of fundamental right under Article 21 of the Indian Constitution. Smoking in public place should be prohibited. So that came with the 2001 Murali S. Diora versus Union of India case. Then Shubha Rao versus State of Himachal Pradesh 1989. Shubha Rao versus State of Himachal Pradesh 1989. In this case, the court ordered the closure of bond factory which was polluting environment by its smell and making the life of the people miserable. And then we have Dr. Ajay Singh Rawat versus Union of India 1995. Dr. Ajay Singh Rawat versus Union of India 1995. In this case, the Supreme Court directed 162 leather tanneries in Tamil Nadu to be closed down because they were polluting the air and the water in the surrounding areas. In this case, the Supreme Court directed 162 leather tanneries in Tamil Nadu to be closed down because they were polluting the air and the water in the surrounding areas. Environmental protection under the Constitution. The Constitution of India is not an inert but a living document which evolves and grows with time. The specific provisions on environmental protection in the Constitution are the result of this evolving nature. A general analysis of the provision of the Constitution reveals that there was no direct provisions relating to the protection of natural environment in our Constitution previously. However, a careful analysis proves that there are various provisions in the Constitution relating to protection and improvement of environment. However, some specific provisions have been incorporated by the Constitutional Amendment of 42nd Amendment Act of 1976. That is Constitutional 42nd Constitutional Amendment Act 1976. The following provisions in the Indian Constitution speaks and relates to environmental protection and improvement. The first is that preamble. In preamble, it is given as socialistic and democratic. That was inserted by the 42nd Amendment. Now, the Union list has state list and concurrent list. Now, Union list, state list and concurrent list. Then the fundamental duties. Then the DPSP, that is Directive Principles of State Policy and the Fundamental Rights. So, under preamble, the term socialistic used in the preamble shows that government must pay more attention to social problems, that is, decent standard of living of people. The term democratic means right to freedom, right to lead dignified life, and right to get information of government policies. Now, with respect to union list, state list, and concurrent list, union list is also known as the list 1 with 97 subjects. It contains the following important subjects, that is the atomic energy, mineral resources, industries, mineral resources, fishing, etc. Now the state list, also known as list 2 with 66 subjects, and it contains the following subjects such as public health, hospital, agriculture, land, etc. And then comes the concurrent list or list 3 with 52 subjects, and it contains the following subjects such as forest, animals, plants, then factories, boilers, electricity, etc. So, fundamental duties and directive principles of state policy. Now, apart from the above provisions, the Indian Constitution obligates the state and its citizens to protect and improve the environment. Part 4 of the Indian Constitution explains about directive principles of state policy, or commonly known as DPSP. Article 48 capital A of the Indian Constitution says that the state shall endeavour to protect and improve the environment and to safeguard the forest and the wildlife of the country. Now, Part 4 capital A of the Indian Constitution deals with fundamental duties. Article 51A, that is Article 51 capital A, contains a list of fundamental duties of citizens. Article 51 capital A subclause G specifically provides that that it shall be the duty of every citizen of India to protect and improve natural environment, including forest, lakes, rivers, and wildlife, and to have compassion for living creatures. That is given in Article 51 capital A subclause G. Now, the Article 48 capital A and Article 51 capital A subclause G imposes twofold responsibility. On one hand, it gives a direction to the state for the protection and improvement of environment, and on the other hand, it imposes a duty on every citizen to help in the preservation of natural environment. Now, directive principles of state policy. Part 4, containing Article 36 to Article 31, lays down the various provisions relating to DPSP. Now, Article 47, 48, 48 capital A and 49 under Part 4 of Indian Constitution of India deals with environmental protection in the following manner. Article 47. It imposes duty of the state to improve public health. It includes the protection and improvement of environment without which public health cannot be assured, nutrition and standard of living improvement in standard of living. Now, Article 48 deals with the prohibition of cow slaughter. Now, it should take steps for preserving and improving the breeds and prohibiting the slaughter of cows. Article 48 capital A. Duty of the state to protect and improve environmental, safeguard forest and wildlife. Now, Article 49. Duty of the state to protect monuments or place or object of artistic or historical interest from spoiling or disfigurement or destruction, removal or disposal or export of such historical interest objects shall be avoided or prohibited. Now, fundamental rights. Part 3, containing Articles 12 to Article 35, provides for different kinds of fundamental rights. But in the case of environmental law, Article 14, Article 19, Subclause 1, Subclause G, then Article 21, Article 26, Article 32, and Article 226 explain about the environmental protection under the Indian Constitution. Now, Article 14, Right to Equality. The state shall not deny to any person equality before law or equal protection of law within the territory of India. In the context of environmental protection, all persons shall have equal right to healthy environment without any discrimination. Now, Article 19, Subclause 1, Subclause A, that is freedom of speech and expression. Now, here, every citizen of India has a right to freedom of speech and expression conferred by Article 19, Subclause 1, Subclause A of the Constitution. The freedom of speech and expression includes freedom of press. The public opinion and news items about the public perception of environment plays an important role in the protection of environment. Article 19, Subclause 1, Subclause A is not an absolute right. It contains certain restrictions under the Article 19, Subclause 2. That is, preservation and conservation of ecosystem is one of such restrictions in which the freedom cannot be invoked as a matter of right. Now, Article 19, Subclause 1, Subclause G, that is freedom of profession, occupation, and trade or business. Any trade or business activity which causes damage to environment can be banned or disallowed, and such a ban shall not be violative of Article 19, Subclause 1, Subclause G of the Indian Constitution. Restriction under Article 19, Subclause 6 is applicable here. A person cannot carry on business or profession in any manner as to make health hazard to the society. Article 21. Life and personal liberty. No person shall be deprived of his life or personal liberty except according to the procedure established by law. The right to live in a healthy environment as part of Article 21 of Indian Constitution was first recognized in the case of Rural Litigation and Entitlement Kendra versus State, that is RLEK versus State, 1988, and popularly known as Dehradun Quarrying Case. Now, in MC Mehta versus Union of India, 1987, that is the oleum gas leak case, the Supreme Court treated the right to live in a pollution-free environment as a part of fundamental right to life under Article 21 of the Indian Constitution. Further, Damodar Rao versus Municipal Corporation Hyderabad, that is in 1987, the right to live in a healthy environment was specifically declared to be part of Article 21 of Indian Constitution. And in addition to this, we have a list of MC Mehta cases, that is MC Mehta case of 1982, that is Ganga pollution case, then in 1992 with respect to carbide case, and 1997 with Taj trapezium case. And then we have Murali S. Diora versus Union of India, where Supreme Court held that smoking in public place should be prohibited, and that was in 2001. Further, in F.K. Hussain versus Union of India, in 1990, the Kerala High Court held that right to sweet water and right to safe water and right to free air are attributes of right to life under Article 21 of the Indian Constitution. And this decision was by Kerala High Court in 1990 in F.K. Hussain versus Union of India. That is right to safe water and right to free air as part of Article 21. Now, MC Mehta case of 1992, that is the carbide case. The Supreme Court held that every citizen has a right to fresh air and to live in a pollution-free environment. Further, in S. Jagannath versus Union of India, that was 1997, the Supreme Court held that the sea beaches and sea coast are gift of nature and any activity polluting the same cannot be permitted. So, the same case law is relevant with also with respect to Coast Regulation Zone Notification, S. Jagannath versus Union of India, 1997. Here the Supreme Court held that the sea beaches and sea coast are a gift of nature and any activity polluting the same cannot be permitted. Now, Article 26 deals with freedom to manage religious affairs. Article 26 deals with freedom to manage religious affairs, and every religious affair shall be carried on without affecting the public order, morality, and health. Now, the next article is Article 31, capital C. Here, immunity of environmental legislation from judicial scrutiny, that was added by the 25th Constitution Amendment. So, Article 31C was inserted by the Constitution, added by the 25th Constitution Amendment Act, and it deals with immunity of environmental legislation from judicial scrutiny. Now, Article 32 and Article 226, which discuss about the writ jurisdiction of Supreme Court and High Court. The writ jurisdiction of Supreme Court is in Article 32, and with respect to High Court, that is in Article 226. Now, environmental pollution being directly related to human health and well-being of the people, the Supreme Court and High Court respectively has the jurisdiction to entertain writ for protection and improvement of environmental and issue directions or order to undo the cause of pollution for the protection of environment from degradation. So, we can conclude it as that environmental protection is a part of cultural values and traditions. In Atharva Veda, it has been said that money paradise is on earth. So, earth is our paradise, and it is our duty to protect our paradise and prevent it from degradation. So, those were given in Atharva Veda. Other than that, we can understand that environmental protection is a part of cultural values and traditions and has been imbibed with various provisions of Indian Constitution, forming the part of the fundamental duty, then fundamental right, and is also protected by the writ jurisdiction. Now, cases under Article 21 which are relevant in this scenario is that Govind Singh versus Shanti Swarup, 1979, and then we have Ratlam Municipality versus Vriddhi Chand, then RLEK versus State, that is Dehradun Korean case. Then the list, we have a list of MC Mehta cases, that is the oleum gas leak case in 1987, Ganga pollution case in 1988, carbide case in 1999, Taj trapezium case in 1997, and Murali S. Diora versus Union of State, where public smoking was prohibited. So that is in 2001. All these case laws comes with respect to Article 21. So that is the right of life and personal liberty. And then with respect to the writ jurisdiction, that is Article 32 and Article 226, we have Ratlam Municipality versus Vriddhi Chand, then State of Tamil Nadu versus Hind State, then MC Mehta. So State of Tamil Nadu versus Hind State was regarding a case where 162 industries or factories were directed to be shut down in Tamil Nadu state to avoid pollution, and they were to move into an appropriate location. Now we have oleum gas leak case, Ganga pollution case, then RLEK versus State of UP, where for the first time the right to healthy environment was brought under Article 21, RLEK versus State of UP, that is 1988. Then in 1999 we have a carbide case, 1997 Taj trapezium case, and prohibition of public smoking, that is Murali S. Diora versus Union of India in 2001. So these are the important case laws in this respect. And now towards remedies for environmental pollution. The law relating to the environmental protection in India can be grouped under two heads, that is common law developed by the courts through judicial precedents, and statutory laws, that is enacted by the legislation and rules made thereunder. The environmental law in India is thus an amalgamation of common law principles and statutory laws. So first we will look into the common law remedies or civil remedies. So civil remedies we have is damages for or compensation and then injunction. Now common law and environmental pollution. So under common law it can be brought under law of tort or we can bring it under CPC. So under tort we have nuisance, negligence, strict liability, absolute liability and trespass. Then there is also criminal remedy that is discussed under IPC and CRPC. So, introduction. A person can avail the following remedies if he is aggrieved by environmental pollution. He can seek remedy through compensation for the suffering he has undergone due to the pollution, or he may seek a remedy to end the pollution. So, what are the remedies? There are 3 remedies available to an aggrieved person. The first one is a civil remedy, the second is a criminal remedy, and the third is writ jurisdiction. So with respect to civil remedy, under law of tort and under civil procedure code, that is CPC, civil remedies are available in the form of damages or compensations or injunction. That is the 2 kind of civil remedies. Then with respect to criminal remedy, we have punishment for public nuisance or removal or abatement of nuisance under CRPC. Then with respect to writ jurisdiction, there the court may direct the concerned agency to enforce the law. So going further into civil remedies, first we are going to discuss about damages or compensations. Now the remedy is in the form of a claim for unliquidated damages. So here it is unliquidated damages. It may be also for prevention of the tortious act, and here the remedy is injunction with or without damages. Now the damages are of 3 types, that is nominal damage or general damages, the second substantial damage or fair claim for damages, third exemplary damages or punitive damages. Now nominal damages or general damages or just mere damages. Here, damages awarded are very nominal. It may be a small amount and not even enough to meet the expense of the filing of the case. This type of damages are awarded for the civil wrongs like trespass, assault, violation of easementary right, etc. Then we have substantial damages or fair claim damages. The compensation has direct proportional to the injury or loss sustained by the aggrieved person. It is a fair compensation to the extent of loss or damage suffered. Exemplary damages. Here, the amount awarded as compensation is usually high. The objectives of the awarding such excessive damage is for 3 reasons. The first, to compensate the aggrieved party. Second, to punish the wrongdoer. Third, to prevent from committing similar acts. So it is also for a deterrent effect. Now the Supreme Court has awarded exemplary damages if the harm has resulted from hazardous and inherently dangerous nature of activity being carried on by the defendant. Now the next is injunction. The next is after compensation or damages we have injunction. Injunction is an important civil remedy to abate or prevent pollution. Injunction is an order or judgment directing a party to the dispute to do or refrain from doing that particular thing. Now, towards types of injunctions. The first one is prevention or restrictive injunction. The second is constructive or mandatory injunction. The third is temporary injunction. And the fourth is perpetual injunction or permanent injunction. So, prevention or restrictive injunction. Here, the defendant is restrained from infringing the right of another person. Example, restraining a person from causing nuisance, infringing a patent right or copyright. Now, constructive or mandatory injunction. By this injunction, the defendant is ordered to do positive act to set right the infringed right of another person. Example, cutting down a hanging branch of a tree over another man's area or removing the waste, etc. Now, temporary injunction. Temporary injunction is granted to maintain the status quo till the trial is decided on this. It is also called interim injunction. So, temporary injunction is also called interim injunction. Then the fourth one is perpetual injunction or permanent injunction. Here, the defendant is permanently restrained to do some act or directed to do some act. Here, given along with the judgment and forms part of the judgment. The next is common law and environmental pollution. So first we are going to discuss about law of tort. Tort is a civil wrong for which the remedy is an action for unliquidated damages. Tortious liability for environmental pollution arises under the following heads, that is nuisance, trespass, negligence, strict liability, absolute liability. Now, nuisance. Nuisance generally mean to do hurt or to annoy. Under the common law principle, nuisance is concerned with the unlawful interference with a person's exclusive right over a land or with some rights over or concerned with it. It may be in the form of obnoxious smell, noise, fumes, air, or water pollution due to the discharge of effluent, or it may be any kind of obstruction which interferes with the right of a person exclusively use a thing. Now, nuisance can be further divided into two categories. These are private nuisance and public nuisance. Public nuisance, it is an act or omission causing injury or damage or annoyance to the public at large and people in general. It is both a tort and a crime. So, a public nuisance is not just a tort, but it is also a crime. And here we have a case law, that is Diamond versus Pierce, 1972. It was held in this case that leaving a lorry on the highway for considerable period was public nuisance. So that was held in Diamond versus Pierce in 1972. Private nuisance. If the nuisance causes injury or damage to an individual or group of individuals, it is called private nuisance. The two important elements of private nuisance are unlawful or unreasonable interference and damages. Now, negligence. Negligence means want of care. Now, every person is under a duty to take care in his activities. When the care is not taken, it may result in causing harm to others. Then we can say that the harm is caused on account of negligence on the part of the defendant. In environmental cases, the tort of negligence is utilized when other tort of nuisance or trespass are not available. An action for negligence may be instituted for injury, damage, or physical discomfort where the effluents, industrial waste, human excreta, etc. are thrown into the municipal drainage, canals, rivers, etc. negligently. And we have a famous case law here, that is Donog versus Stevenson, 1932. Donog versus Stevenson, 1932. Here the court held that the defendant has a duty to take care towards the plaintiff if the injury is foreseeable. If the injury is not foreseeable, the defendant owns no duty of care towards the plaintiff. And the next we have is trespass. So the third heading under tort is trespass. The term trespass literally means unauthorized interference with the possession or enjoyment of another's land. With regard to trespass in environmental law is concerned, the employers of the industries are required to take necessary steps to prevent environmental pollution by regulating the release of waste and effluents into the surrounding lands, area, etc., canals, etc. The release of such industrial waste into the surrounding places is called trespass to the land in environmental. Now the fourth one category under tort is strict and absolute liability. There are certain circumstances in which a person is made liable without any fault or intention or negligence on his part. The liability arises from for a breach of duty on his part. Such liability is called strict liability. The doctrine of strict liability was coined or propounded for the first time by Blackburn Justice in the case of Ryland versus Fletcher, and hence it is also known as the rule in Ryland versus Fletcher. Ryland versus Fletcher is a case that came in 1862. The rule of strict liability is subject to the following exceptions, that is, act of God, the act of third party, the plaintiff's own fault, then the plaintiff's consent, the natural use of the land by the defendant, and statutory authority. So the rule of strict liability is subjected to these exceptions. Now, the doctrine of strict liability has been widely applied in the case of environmental pollution, especially in the case where the harm is caused by the leakage of hazardous substance. To apply this rule, two conditions must be satisfied. First, there must be no natural use of land, and second, there must be escape from the land of something which is likely to cause harm or mischief to others. And then we have absolute liability. The rule of absolute liability is developed from the rule of strict liability evolved by Blackburn Justice in 1862 in the case law of Rylands versus Fletcher. Now, liability of defendant under absolute liability is more when compared to strict liability. Strict liability provides for certain defenses to the defendant to get exemption from the liability, whereas the absolute liability provides no defense and defendant has no chance to escape from the liability. And this was applied in MC Mehta versus Union of India in 1987, and that is the oleum gas leak case. The Supreme Court of India laid down the rule of absolute liability in preference to the rule of strict liability as laid down in Rylands versus Fletcher in this case. Now, absolute liability is liability irrespective of negligence on the part of the defendant without defense. And absolute liability was laid down or applied for the first time in oleum gas leak case or MC Mehta versus Union of India 1987. Now, strict liability is liability irrespective of negligence on the part of the defendant with certain exceptions or defenses, and that was coined by Blackburn Justice in Ryland versus Fletcher in 1868. Now, the next we have is statutory remedy, or we will discuss about criminal law remedies under statutory remedy. So, provisions under IPC Chapter 14 of IPC containing sections 268 to section 290 deals with the offence affecting the public health, safety, convenience, decency and morals. So that is chapter 14 sections 268 to section 290 of IPC that deals with public health, safety, convenience, decency and morals. So, Section 268 deals with public nuisance and Section 290 provides the punishment which is 200 rupees. Section 291 provides for the nuisance is still continuing, then the punishment is with simple imprisonment for 6 months or with fine or both. Now, Section 268 is public nuisance and Section 290 is a fine that is of 200 rupees. Section 291 discusses about the continuing of nuisance or continuing of offence, and there is a simple imprisonment of 6 months or fine or both. And then we have section 142 and 143 of IPC for injunctions. Then we have section 269, that is the spread of infectious diseases, that is also punishable with 6 months of imprisonment or fine or both. Then section 270, that is spread of malignant as act, and that is imprisonment up to 2 years or fine or both. Then section 277, that is punishment for polluting water, and that is punishable up to 3 months with a fine of 1,000 rupees. Then we have section 278, punishment for making atmosphere unhealthy for humans as well as other living beings, and that is punishable with imprisonment for 6 months and a fine or a fine of 1,000 rupees or both. Then we have section 433 that is related to mischief, and here the punishment can be up to 5 years with or without fine. Now we have section 435 that is mischief by fire to cause damage, that is punishable up to 7 years of imprisonment with fine. Now section 436 that is mischief by explosive substance intended to destroy house, and that is punishable up to 10 years with fine. And these are some of the main sections under IPC, that is not only related to chapter 14 that is section 268 to section 290, but also include mischief that is discussed under section 433, 435, 436. So further, for punishments under section 291, the complaint must be first obtained in an injunction under section 142 or 143 of the Code of Criminal Procedure. So when you have to make a complaint with public nuisance, first we obtain an injunction under section 142 and section 143 of CRPC, that is to prevent further harm. We get an injunction under these sections to avoid or prevent further harm. Then section 269 provides whoever unlawfully or negligently spreads the infection of any disease dangerous to life shall be punishable with imprisonment for 6 months or with fine or both. Section 270 provides for punishment for some malignant act which is likely to spread infection of disease and which is dangerous to life shall be punishable with imprisonment of 2 years or fine or both. And this section, most of us will be familiar with section 270 of IPC because this section was mostly applied during the COVID situation and when there was a lockdown to avoid the spread of COVID. And at that point, section 270 was made applicable. Now, section 277 provides for punishment for fouling water, and public water or public spring or reservoir shall be punishable up to 3 months or with fine or with a fine of 1,000 rupees or both. Now section 278, which lays down punishment for making atmosphere noxious to health, shall be punishable with imprisonment of 6 months or with fine of 1,000 rupees or both. Then we have section 433 with respect to mischief. Then 435 with respect to mischief by fire intending to cause damage. Then we have section 436 mischief with explosive substance, and the penalty is different. For mischief it is imprisonment up to 5 years or fine or both. When the mischief is done by fire to cause damage, the imprisonment may go up to 7 years with fine. Now under section 436, that is mischief with explosive substance, the imprisonment may go up to 10 years with fine. The next statutory provision we have is with respect to CRPC of 1973. So here section 133 to section 144 of CRPC deals with prevention and control of public nuisance causing air, water and noise pollution. Then section 163 of CRPC, a district magistrate or subdivisional magistrate or executive magistrate on receipt of a report from public officer or on receipt of any other information can make a conditional order to remove the public nuisance causing pollution. That is section 163 of CRPC. Then under same section, he can also make the conditional order to abstain, and if any person fails to comply with the order, he can be punished under section 188 of IPC. Now we have provisions under CPC. So we discussed about IPC, CRPC and CP. Now we have provisions under Code of Civil Procedure 1908. Here section 91, public nuisance and other wrongful acts affecting the public, is discussed in section 91. In such a situation, a suit for declaration and injunction or any such relief can be claimed, that is A, by an advocate general, B, with the leave of the court, by 2 or more persons, even though no special damage has been caused to such person by reason of such public nuisance and other wrongful act. So, now the person causing air or noise pollution or causing public nuisance are liable for prosecution. However, that penalty for such offence is merely 200 rupees. Now, provisions under the Central Motor Vehicles Act rules 1989. So, we discussed about IPC, CRPC, CPC, and now the next statutory provision we are going to discuss is provisions under the Central Motor Vehicles Rules 1989. In the exercise of this rulemaking power, rulemaking power is conferred under Section 110 subclause G and 110 subclause H and various other sections of the Motor Vehicles Act of 1988. Now, the central government made the Central Motor Vehicles Rules in 1989. The Rules 112 to 116 contains various provisions to control and prevent air pollution resulting from the emission of poisonous gas from vehicles. The Rules 119 to 120 contains provisions for control and prevention of sound pollution resulting from the use of horn and exhaust gas from the engine. In addition to the above statutory provisions, the following statutes also help in protecting environment from pollution. The first one, the Wildlife Protection Act of 1972. Then we have the Water Prevention and Control of Pollution Act 1974. Then the Forest Conservation Act of 1980. The Air Prevention and Control of Pollution Act of 1981. Then the Bhopal Gas Leak Disaster Processing of Claims Act of 1985. Then the Environment Protection Act, that is 1986. The Public Liability Insurance Act of 1991. And the National Green Tribunal Act of 2010. Then the other remedies we have is the writ jurisdiction under Article 32 and Article 226. Then we also have the constitutional remedies that we already discussed. So that is with the remedies with respect to environmental pollution.